I take pleasure in that, Judge.
Yeah.
Good evening, everyone, and welcome to the Edward M. Kennedy Institute for the United States Senate. I'm Adam Hines. I'm the CEO here, and I'm thrilled to welcome you all this evening, including the more than 400 people who registered online. It's really a pleasure to have you in this space for this conversation. We are proud to partner with the American Academy of Arts and Sciences on this evening's program, and a timely and important program it is indeed. I'll introduce the Academy's president shortly. And a special thank you to our members who are here tonight. I've spoken with a few of you already, but we appreciate your continued support, and it helps us put on programs like this. We're excited that shortly we'll be announcing our lineup for the 2024 in-person and online events as well, so keep an eye out for that. This really is an exciting time for the Institute. We have another announcement that you should keep your eye out for. We're going to soon release the details on two new Institute Fellows, which, and how to apply for them, importantly. And this is the first time the Institute has had fellows, and these are aimed at postdocs and senior U.S. Senate staff members who might want to take the time to reflect on the current state of affairs in the United States Senate. And I'll say that with every day and every new program we launch, we aim to further enhance our role as leaders in strengthening American democracy, in particular with a focus on the U.S. Senate. That includes our Hyannis Sports Summits that we convened this summer at the Kennedy Cape House. And we brought together 10 former U.S. senators, 5 Republicans, 5 Democrats, so that they could spend a weekend together identifying the ways to enhance the functioning of the United States Senate. And we teamed up with the McCain Institute for that work, and we're working with them to this day to make sure we can move those recommendations forward. We're already planning additional gatherings for 2024. Last month is another example of our work in strengthening American democracy. We convened our 4th Senate Project debate, bringing together 2 current senators to model deliberation on issues of national importance before a national audience. And the important result was that we had national leaders saying very clearly the importance of protecting our democratic institutions and norms as we enter the 2024 election. And in fact, today in the Hill, the participants in that debate, Marco Rubio and Chris Coons, co-authored an op-ed along those lines. And our partners with that is the Orrin Hatch Foundation. And you can see a theme here that we're working with institutes on the other side of the aisle, and we have additional announcements for programming along those lines soon. And then certainly, last but not least, in this room, this exact replica of the United States Senate, every single year, 15,000 students walk through the doors that you walk through so that they can learn the importance of not only how a bill becomes a law, and they debate everything from climate change to immigration, but also how to engage in dialogue across differences. And we continue to grow that into a nationwide program, including 17 states. So I know that Senator Kennedy would be proud to see that work. And I know that as a longtime member of the Committee on the Judiciary, he would have loved to get into the thick of the conversation ahead of us tonight. And one person who would know that is our moderator, who I'm going to let President Oxtoby introduce. But Judge Patty Saras is roundly beloved in these parts as a Kennedy alumni, and was counsel to the U.S. Senate Committee on Judiciary. I believe at the same time the senator was the chair.
Yes.
Okay, that's right. So in the late 70s, early 80s. But now, to take us into this evening's event, I have the honor of introducing the president of the American Academy of Arts and Sciences, Mr. David Oxtoby. He will introduce the esteemed panel and the impressive work conducted by the Academy related to Supreme Court reform. President Oxtoby is a chemist by training. He served as president of Pomona College from 2003 to 2017, and previously served as a dean of the Division of Physical Sciences at the University of Chicago. And much more on his resume that I guess I should refrain from going into. But Mr. President, we truly have enjoyed this opportunity to work with you, and I yield the floor.
Thank you, Adam, and thank you to the Edward M. Kennedy Institute for co-hosting tonight's event. On behalf of the Academy, I'm grateful to all of our excellent panelists for being here this evening. We're proud to be celebrating the release today of a new publication from our U.S. Supreme Court Working Group, The Case for Supreme Court Term Limits. The American Academy was founded in 1780 by John Adams, John Hancock, and other patriot scholars to advance learning and knowledge in service to the public good for the new nation. Today, we are a learned society and nonpartisan, independent policy center. The Academy's work on the topic of tonight's discussion began in 2018 when we convened our Commission on the Practice of Democratic Citizenship. That commission included a diverse set of leaders from academia, government, civil society, politics, and business, with views spanning the ideological spectrum. In 2020, it issued its landmark final report, Our Common Purpose, Reinventing American Democracy for the 21st Century, which contained 31 bold but feasible recommendations, including 18-year term limits for Supreme Court justices. Our Common Purpose argued that increasing polarization surrounding the court, especially in the appointments process, has been due in part to the fact that justices today live far longer and thus serve far longer than the founders are likely to have imagined. The Commission believes that moving toward a system of regular appointments in 18-year terms could restore the founders' vision and move the court toward a less partisan future. This reform has long had support from legal scholars across the political spectrum. It's also incredibly popular with the public. More than 2/3 of Americans, including majorities of both parties, support term limits for justices, according to an AP poll conducted earlier this year. Despite this broad support, the reform has nonetheless been difficult to implement, in part because there remained a great number of outstanding questions about how exactly it would work. For instance, how will a transition to term limits be handled? What will be the scope of justices' post-term duties? And perhaps most importantly, can this reform be implemented by statute, or will a constitutional amendment be required? Last year, the Academy assembled an accomplished, bipartisan group of constitutional scholars and political scientists to answer these questions and create a roadmap for implementation. The working group deliberated over the course of 8 months, systematically working through these issues and reaching consensus on each. The thoughtfulness, thoroughness, and energy that they brought to those conversations was both impressive and inspiring. Two of tonight's panelists, Professors Akhil Reed Amar and Charles Freed, were among this group. We're grateful to them and to all of the working group members for sharing their time and expertise. The Case for Supreme Court Term Limits summarizes the conclusions the group has drawn. We're thrilled now to be able to share this work with all of you. We look forward to a lively discussion from tonight's panel. With that, I would like to now introduce the moderator for our event, Judge Patty Saris of the U.S. District Court for the District of Massachusetts. Judge Saris served as Chief Judge from 2013 to 2019 and Chair of the United States Sentencing Commission from 2011 to 2017. A graduate of Radcliffe College and Harvard Law School, she served as staff counsel for the Senate Judiciary Committee under Senator Edward M. Kennedy before becoming an assistant United States attorney and eventually chief of the Civil Division. Judge Saris currently serves as lecturer in law at Harvard Law School. She was elected a member of the American Academy of Arts and Sciences in 2014. Thank you, Patty, for joining us this evening.
Thank you, David. Can you all hear me? I have to project my voice as, like I do in the courtroom, so I want to make sure everyone can hear. I want to welcome everybody here this evening, both here in person as well as I think a lot of people signed on. It's being streamed on YouTube. As you heard, I am the former Chief Judge of the Federal District Court of Massachusetts and former Chair of the United States Sentencing Commission, but I emphasize that I sit here on my own behalf and on behalf of the courts. I learned a lot from my former boss, Senator Edward Kennedy, who cared deeply about the role of the legislative branch in addressing important justice issues. I worked for him when he, as you heard, when he was chair of the Senate Judiciary Committee. My boss was also then later Justice Stephen Breyer. It was a very exciting time to be on the Judiciary Committee. When I was there, he made sure that I met Justice Sandra Day O'Connor as she came through her confirmation process. It was a much less partisan time, and so much has changed. Thank you to the Institute, again, for hosting this important event. Thank you to the Academy for exploring this important issue. I know Senator Kennedy would have loved it. And the one secret I will share is that when I used to staff him sitting at, I think, a desk maybe over there somewhere. I looked very serious in staffing him, but he was actually handing me candy from within the desk. So he treated us well. Today we will address a proposal by the U.S. Supreme Court Working Group of the American Academy of Arts and Sciences, of which I am proud to be a member. As you heard from David Oxtoby, the president, this working group considered the idea of term limits for Supreme Court justices derived from its report, Our Common Purpose, Reinventing Democracy for the 21st Century. And the working group has now published today, hot off the press, its recommendation that 18-year term limits be imposed by statute. Tonight we have a panel of extremely impressive constitutional scholars, a legislative advocate who's making a difference down in Washington, D.C., and a prominent journalist, I always read her column, to address these important issues that we've been talking about. Why should we adopt such a legislative proposal? Is it constitutional under Article 3, which entitles Supreme Court justices to hold their offices for life during good behavior? Are we really talking about term limits or something else? So quick intros, and then we get going with the discussion. I begin with Akhil Reed Amar, who teaches constitutional law at Yale Law School. He's a Sterling professor and the Sterling professor of law and political science at Yale University. He's been cited by Supreme Court justices in more than 4 cases and ranks among America's 5 most cited mid-career legal scholars. His most recent work, The Words That Made Us, America's Constitutional Conversation, 1760 to 1840, just came out in May of 2021. He was elected to the American Academy of Arts and Sciences in 2007. Kimberly Atkins Storr is a senior opinion writer and columnist for the Boston Globe. She is also an MSNBC contributor, co-host of the Politicon podcast, Sisters in Law, and guest host on WBUR's On Point. Before launching her career as such a prominent journalist, though, she was in my neck of the woods as a trial and appellate attorney in Boston. She was just elected, and we should congratulate her, to the American Academy of Arts and Sciences just like 2 weeks ago, 3 weeks ago. So Charles Freed has been teaching at Harvard Law School since 1961. He served as Solicitor General of the United States from 1985 to 1989 under President Ronald Reagan, and as an Associate Justice of the Supreme Judicial Court of Massachusetts from 1995 to 1999. He was elected to the American Academy of Arts and Sciences in 1997. Last but by no means least, Gabe Roth is the executive director of Fix the Court, a nonpartisan 501c3 organization that advocates for non-ideological fixes to make the federal courts more open and accountable to the American people. He previously managed the Coalition for Court Transparency, and before that worked in political consulting in Washington, New York, and Chicago. So that's our terrific panel, and I'm just going to kick it off by asking Akhil the first question. So you were part of the working group and have advocated a statutory approach to the Supreme Court term limits. Can you give us an overview? How does it work? What's the case for having 18-year terms? And tell us how this whole proposal would work and why it would make things better.
Honor to be with you all. So the most important thing to emphasize is that this idea has deep roots and deep bipartisan roots. And if the statute is to be enacted, it's very important that there be buy-in across the political spectrum in a way that Senator Kennedy, I think, would have liked, but Senator Orrin Hatch, who was mentioned before, would have liked. Way back when, about 18 years ago, in fact, I'm a registered Democrat. I co-authored a piece with Steve Calabresi, the founder of the Federalist Society, co-founder, the president of the Federalist Society. He's a registered Republican. And in the WashPo, we put forth this idea. And as you heard, the committee that has now generated this suggestion is a bipartisan group. 18 turns out to be a pretty good number because there are 9 justices. And so then basically if you put them on, if the court replenishes basically 1 new justice on average every 2 years, and that would give each president, who has a 4-year term, basically 2 picks. So the math works out pretty cleanly, but why is it an improvement? I got a free weekly podcast. It's free. At one point, I actually counted up, I think, 18 different reasons why this might be a good idea. Let me just identify 3 or 4 of them, and then you asked a question, well, is it constitutional? Can you do it with a statute? So at one end, let me just take a step back. No country in the world, no major democracy, advanced democracy, has a life tenure model. And so if it's so perfect, why isn't this being emulated? Of the 50 states, only 1 does. Rhode Island, it has the reputation not of being necessarily the best governed state in the nation. We'll just leave it at that, put it gently.
I may want to strike that from the record.
Okay, so that's why I shouldn't have gone there at all. I do not want to be held in contempt, so I withdraw, Your Honor. But that's some input from our fellow citizens about, so we think actually 18 is a superior model of judicial independence. We believe in judicial independence. Here are some reasons it's superior. So one point is if people are staying very, very late, they may be a bit superannuated, and that might not be their best years of judicial service. At the other end, you see I'm offending everyone here. So at the other end, there's an arms race if each party, if it's life tenure, going younger and younger and younger, and they're on the court maybe for a little too long, and that creates too much of a sense of their of entitlement, because power can corrupt. I love that you're all here. Look around, the very few young people, maybe on YouTube, but very few. And if they're there for...
Wait, we've got some raising their hands over there.
A few, right, but you're not proportionally represented, and here's a problem for the young people. If they're lasting for 30 years, they were nominated before you were even born. If they're for 18, oh, and there's going to be regular replenishment. So there's always going to be another one in 2 years. So for Philly fans, they say, well, wait till next year. Well, now, actually, you can just wait. I'm offending everyone here, I see. But you're never more than 2 years away from another appointment, whereas things can be very nasty if you think this is for 40 years. And there's a knockdown, rather than there's going to be 1 2 years, and 1 2 years after that final thought. As I said, 18 different reasons at least. People now politically time their resignations. And that's actually not a good thing. They're acting politically in basically trying to clone themselves in certain ways. There are other reasons as well. It regularizes things. Jimmy Carter got 0 appointments in 4 years. Donald Trump got 3. There are lots of reasons why this is actually a good system. And the final thing you asked is, can it be done constitutionally? I think so. I think my colleagues think so. We can talk more about it, because strictly speaking, it's not quite term limits. You're on the court for life. You have the title of justice for life. Your salary cannot, and as I get older, I think about this a lot because I've got tenure too. My salary can't be diminished, okay? And that's for life. But your job description changes after 18. It's kind of phased service. You're on the front bench for the first 18 years, and then you're actually doing more senior status thereafter. And you can help in all sorts of ways, including, for example, enforcing judicial ethics rules against the front bench. There are all sorts of things that you can do.
I knew we'd hit that question.
So if you believe in judicial ethics, right now, if a justice recuses, that leaves the court short-staffed at 4-4. That's not so good. In our world, a justice recuses. There's a senior person at the ready who knows the job, knows the drill, pinch hitter, designated hitter, whatever, who can come in and do the thing. There are many reasons for this, and we think it can be done constitutionally.
That senior status is not is already established in the lower federal courts, as we're called inferior courts. So the senior status applies to the trial court.
And some of our great retired justices, like Stephen Breyer and the great David Souter and Anthony Kennedy, they themselves are continuing to serve on the bench for free because these are people who are absolutely committed to public service. And we think that's true of the justices as well. So we think it's actually a reform that will improve judicial independence. We think it's popular with the people. We think it's constitutional, but if you have questions, we're happy to field them.
Just one more thing. So at some point what do we do with the justices who are already there?
We're not going to kick anyone off the train. Okay, throw them from the train. So what that means, because that would look very partisan, because you know who it would be, and it wouldn't be behind a kind of veil of ignorance, because you know who the most senior people are. So as a practical matter, what this means is the court's size will temporarily increase, and then eventually, as people rotate off, it'll be a stable set of 9. So basically, going forward, every president gets 2 guaranteed appointments, and for a while, the court will increase in size, but eventually it'll settle down to 18.
I don't know if you can say
to 9.
Grandfather anymore. Maybe it's grandfather, grandmother, in the people who were there. And then you'll be expanding the court beyond 12 for a certain period of time, and it'll come back down.
Beyond 9, yeah.
I mean, I'm sorry, beyond 9, I think in my juries. Yeah, beyond 9, and then it comes back down.
But it'll settle
again.
back down.
Okay. So, Professor Freed, is it constitutional? As former Solicitor General, what's your view on this?
Well, there is no text in the Constitution which mandates the opposite. It says you hold office during good behavior, but there's no such office as a sitting Supreme Court justice. The office is as a judge, and that is the office, and you have that for life. And that is the theory. So during that life, 18 of those years are spent as a justice of the Supreme Court, unless you fill in for somebody, or that's a detail. And so I don't know what there is in the Constitution which this violates. I think there is nothing. And the question is, we've never done this. Well, we haven't, but there's nothing in the Constitution that prevents us from doing it. And as Chief Justice Marshall said in the beginning of the 19th century, this is a constitution we are dealing with. He didn't use that word. And what he meant by that, because it's often misconstrued, what he meant by that, it is a framework for government. It is a framework within which government can adapt to situations. And one of the things that this proposal adapts to is, first of all, much longer lifelines. And the other thing it adapts to is a much more partisan spirit. And that requires adaptation. And as Chief Justice Marshall explained, this Constitution is capacious enough to allow adaptation as you go on. Now, there's another virtue, which is a rather subtle one, which Akhil did not mention, and that is this proposal would remove the incentive for presidents and partisans to appoint younger and younger justices. And the reason I think that is important is that, and here I would cite Aristotle, it takes a while to develop a character and to develop virtue and to show what kind of person you are. And you may not really see that in your 30s and indeed in your 40s. We have seen that as people mature, we get a better sense of what they are. And I think a very important aspect of that is the kind of law that we have. And I have taught, and I do teach constitutional law, and in that I see that we've got a lot of rules. The constitutional law is a very complex body of rules. The Constitution itself is 7,500 words. There are almost 600 volumes of Supreme Court reports. And those reports are full of precedents, and those precedents are full of attempts to lay down rules. And what is required, and this is an Aristotelian virtue, what is required is the common sense to see when a rule has given out, when you are at the border of a rule, or when you are at the border of two rules. And really you've got to say, which box does this go into, and what is it that makes sense? And I would trust somebody who has a reputation, who is known, who has litigated cases for 20, 30 years, or sat on a different court for 20 or 30 years, to make those decisions wisely. And there is no rule which will tell him or her how to make that decision. It is a question of temperament and of prudence. And prudence is something you learn with time. And I think that there is a chance that Supreme Court justices will be prudent and will make sense. I have seen this many times. A very nice example for me is Chief Justice Rehnquist, who I knew when he was a man in his 50s, and in his 60s and 70s, he began to make a little bit more sense. He wasn't so doctrinaire. he would say things like, there's got to be some play in the joints. He said that in a religion case. That is a remarkable thing. Justice Breyer said that, you know, these rules are more like rules of thumb. They are not laid down somewhere. They are not geometry. And if you're going to treat the rules of law as rules of thumb, you better be a wise person whose virtue and temperament other people have come to know. And when they chose you, when they confirmed you, they confirmed a person who their professional colleagues, the people who they worked for, the clients that they served, the opponents that they battled as lawyers, have come to see are fair-minded and have a sense of humor and know how to deal with things. Justice Kagan, who was my dean, had a wonderful phrase, which one moment. I had a wonderful phrase in a case where Justice Thomas was putting things into boxes, the size of signs. It was not the world's most important issue. And what Justice Kagan said, you know, maybe we can relax a little bit. Maybe we can let down our guard a little bit in terms of putting things into boxes. And if you're going to do that, I want people who have come to know and who have come to show themselves.
That's great. So you think it's going to improve the quality of the justices on the Supreme Court? And
I hope so.
I do too. And so those are good examples. So Ken, you've spent most of your career covering the courts and the politics surrounding the Supreme Court. So you've heard here a good case for why you should do this. What's your view on all this?
Yeah, so I've covered the court for a long time. I covered the court as a beat, and now I went back and looked since I've been a columnist at the Globe, and maybe about half my columns have been about the court. And you say covering the court, the law, and the politics. At first, my job was just covering the law. It's the politics that crept in that required me to cover the politics more and more. And if you'd asked me, maybe even 5 years ago, about reforming the court, maybe even 3, I was not for term limits. I was not for making some of the wide-ranging reforms in response to what was happening, because I'm very wary of if an institution is not giving the result that you want to see, I don't think that the first solution should be to change it. I understood too, I want to talk a little bit about why the framers gave life tenure to justices and judges, and the idea was that the other 2 branches of government are inherently political, but the judiciary should not be. And the thought was by giving them life tenure, by not making them have to worry about campaigning or trying to keep their jobs or worrying about public opinion at all, because that's not what their job is, that would ensure that independence. Well, we have seen in real life that that's not how it works, and it's probably not how it's ever worked. But because, and especially recently, because of some investigative journalists, which I will give a little shout out to the Fourth Estate right here, we know from reports in publications like ProPublica and the Washington Post and Politico how dark money, how deep-pocketed influencers and influence campaigns have really found a way to break through that guardrail that was supposed to be for independence. So I see life tenure as a good idea that didn't work. And I have come to think that term limits are a smart idea. I think the 18-year with 2 appointments per presidential term is really great. That works out great mathematically. I am not for packing the court, expanding it, but in this case, the temporary expansion, because I know people groaned when we said that justices wouldn't be kicked off the court under this proposal. That would pose a very big constitutional problem to kick the justices off the court, and that's a fight that I don't think we want to wage. And I think the way the math works out, the court won't expand by very much. I think at most it'll probably be 10 or 11 at any given time, depending on how long people stay on. But then back down to 9, I think that's a reasonable, workable number. And I think that brings back to, if not the exact word or the exact thought by the framers about how this would work, it would be within the spirit of that. I have been when I began covering the court, Supreme Court justice confirmations, they would get testy, the hearings, people would get their sound bites in and stuff, but at the end of the day, there would be very lopsided votes. And we used to think a lot about, I thought a lot about, or I've been asked about when that changed, and I think the conventional wisdom is that it changed with the nomination of Robert Bork, which that was quite political, and he ultimately was not confirmed. But even after that, Ruth Bader Ginsburg was confirmed, and other justices after that were confirmed by nearly, if not unanimous votes. So that wasn't when everything broke. But I think within the last decade, we have seen a real disintegration, both with the actions of people in the Senate and also outside influences that make this really, really urgent and make me agree that this is the right move.
And one of the arguments for it is, like Professor Fried said, maybe you'd improve the quality of the kinds of people who go on.
Absolutely.
Do you think it would also decrease partisanship?
I would hope so, because it takes the incentive away. If we know that every president gets 2 nominations, look, you can't take the partisanship out of it completely. There will be ways that people poke holes in whatever system is adopted, if a system is adopted. But I think this is one of the areas where the loopholes were so big that you could drive a truck through, and the people with the special interests found the way to get the biggest truck that they could get and drive it through. I think this closes the holes a bit. So at least, they may send mice in with little things, but it's just not as big. I do think it would reduce, but not eliminate the partisanship, yes.
Thank you. And so, Gabe, just moving on to you a bit, do you think it'll fix the court?
I think it'll go a long ways towards helping it.
All right, so tell us what's going on in Congress right now and the new bill that was just proposed.
Yeah, there is some movement in Congress, at least from the introductory facet. There, in the previous Congresses, really for a very, very long time, there were no bills in Congress on limiting life tenure at the Supreme Court or changing the tenures. There were a few constitutional amendments that were proposed really pretty much about every 10 or 20 years from the founding up until the 70s, but that kind of slowed down in the 80s and 90s. And then I think with the Gingrich Revolution, a lot of things slowed down in the Congress. But more recently, there have been several bills introduced that would institute prospective 18-year term limits, 3 in fact, including one that was introduced earlier this month. So one would do a lot along the lines of what the American Academy of Arts and Sciences report would do. So 18-year terms, a new justice every 2 years, not pushing anyone off the bench, so the bench would expand slightly for a few years. Then there's another proposal so that's from Ro Khanna of California. Then there's one from Hank Johnson, a fellow House member from Georgia, that would institute 18-year term limits. But the second that, say, just to use an argument, let's say Michelle Childs is a judge in the DC circuit now. As soon as she gets on the court and is confirmed, that means that Clarence Thomas, the longest tenured justice, would not be part of the panel hearing all the cases. So it essentially pushed a justice off the court. So that's the Hank Johnson version. And then another 2 years would go by, and say Leandra Kruger would push off John Roberts, et cetera. Assuming it's a President Biden, obviously I would be different with a different president, but let's just go with that assumption for now. We are in the Kennedy Institute. I think that's his party. They serve together. They serve together,
yeah.
right? Well, just in terms of who's going to be the next the president after 2024. But anyway, then the more recent bill from Senator Whitehouse of Rhode Island would effectively split the jurisdictions. Now, what does that mean? So it's very much like the Hank Johnson bill. So Michelle Childs would replace Clarence Thomas only on appellate jurisdiction cases. So Clarence Thomas would still get to hear original jurisdiction cases. The problem, of course, is that 99.998% of cases that the justices hear are appellate jurisdiction cases, so it's effectively the same as the Hank Johnson bill.
So explain to them the difference, just to make sure people are getting it. Yeah.
Well, are they consuls and ministers out there? Is that why? So yeah, Article 3 of the Constitution, why am I talking about the Constitution when the biographer of the Constitution? I am not a lawyer. I just want to,
All right. Why don't I move it?
No, but
why
just-
don't you finish
Can I
and then
just
I'll go
mention,
back.
though, all of these proposals share the 18-year
Correct.
idea. So that's actually interesting. You know, there are wrinkles and variations, but 18 is the common denominator.
Yeah, just basically with original jurisdiction, it's like one case per term. So the Constitution says that certain cases have to go to the Supreme Court. So like when Tennessee sues Mississippi over the groundwater in the Mississippi River, which they do every couple of years, that case has to go straight to the Supreme Court. Yeah, as the trial court, exactly. So every other case that you've heard of under the sun, pretty much, besides Tennessee versus Mississippi, is appellate jurisdiction. So I think, personally, the proposal is too cute by half. I like the Ro Khanna proposal. It's consistent with the report that just came out and doesn't kick anyone off the court as much as we might want certain justices not to be hearing cases right now or into the future. I do have the same constitutional concerns that Kim mentioned, and that's why I think, personally, the proposal that you all are here to hear about is more elegant and more constitutionally kosher.
And what are the chances of any of these statutes passing?
Oh, goodness. It's hard. It's very difficult. Unfortunately, right now. So, when I started Fix the Court in 2014, term limits wasn't a fix because term limits were associated with conservatives. Conservatives love term limits. Convention of the States, the term limit amendments in the 90s that were proposed for Congress and then in the 2000s as well. Term limits was like a conservative idea. So I can't propose term limits to the Supreme Court because all of my the work on it is like from Josh Hawley or Ted Cruz or Ron Johnson or whoever. Fast forward, and it's totally flipped, right? It is currently Democrats who are pretty much only, at least in Congress, supporting term limits or the 18-year proposal. So that makes it very difficult. And I think the reason is because conservatives are on the upswing in the court, and they see incorrectly, but this is just sort of, so they don't have to think about it. They'll just say, okay, any attempt to change the way the court functions is an attack on conservative jurisprudence. When that's obviously not true. The idea of term limits, like the anti-federalists thought of term limits, this is not a new idea. So, to sort of change the sort of that paradigm, I think is going to be a challenge. But that being said, as Senator Kennedy would know better than anyone, it takes several Congresses of introducing these types of bills for them to gather momentum. So, for example, the Ro Khanna bill, this is the third Congress it's been introduced. The Hank Johnson bill, this is the second Congress it's been introduced. The White House bill, okay, it's the first Congress. There's another bill or two that might come out on term limits, which also would be 18 years for what it's worth, that I'm working behind the scenes on. So, I think that it's going to take some time to sort of get this, a bipartisan consensus again. But, I'm only 41, so I will take as long as it takes to do it.
I was just going to jump in and say, look, I feel often that my job is shouting into the void and, talking about things that I think are important and I'm passionate about, but that have a very small chance of changing. But a lot of things, especially when you think about our laws, our Constitution, our institutions, our country is relatively young. And if this happens, it may not happen for 10, 20, 30 years, but I have great hope for a future when the political winds will just be blowing in just the right way, where both parties, or however many parties we have at that time, will see that it's in their interest and it's in the interest of justice to do this. It's in the interest of good governance, and it's in the interest of instilling trust of the American people in our institutions and the rule of law to do this.
So I'd like to return to the Constitution, which I'm holding up here. And you may not notice this, but Akil is wearing the Constitution on his tie. So, we've got two constitutional scholars here. Article 3, Section 1 says that federal judges shall hold their offices during good behavior. The gist of this proposal is to shift what their duties are during that office, but really a significant shift. They're no longer handling the kinds of cases you read about, whether it's affirmative action or abortion or First Amendment or religion. They're no longer handling those. They're handling whether it's the original jurisdiction cases or maybe riding circuit the way they always used to. So why is that constitutional?
Well, you heard Charles say that basically what you're guaranteed is your undiminishable salary, and you keep that, and you keep your title. We could call you a judge. Actually, that's what Article 3 says, or a justice, a word that goes back to the Judiciary Act of 1789. So I did bring a few of my pocket constitutions here. I've got some more in my back pocket.
I was going to say, you have a lot of pockets.
Yes. Oh, yeah, here's another one. Okay. Wait. Well, there's one more. Okay.
You win.
And I am wearing, this is not just for show. My student, David McCullough the Younger, will confirm that this is what I always do. I'm wearing my Constitution. Oh, here are my Lincoln socks. Okay, I could be wrong. But this is what I do every day for the last 40 years, because I was hired, at a young age, too. I get up and I think about the Constitution, and I brush my teeth, and I think about the Constitution, and I take a shower, and you got it, okay? I don't bring these in the shower with me because they'd get soggy, but I could be wrong. But I think it's constitutional for the reason that Charles said, because what is guaranteed is not your current job description. And indeed, over the years, we've added jurisdiction to the Supreme Court. We've taken away jurisdiction to the Supreme Court. We've done that for lower courts, who also have Article 3 tenure. We've modified the duty roster to some extent. But you always are a judge or a justice in Article 3 with undiminishable salary, and that stays intact. One final thing, if we're going to do it, in effect, only purely prospectively, two things. One, you could have a rule that is adopted today, but only starts 30 years from now. Behind a veil of ignorance, we don't know whose ox is gored. So, but if it's a good idea in principle, and again, most states think something like this is, and most countries in the world think that something like this is. So that's one thing. We could sort of delay the phase in, but the and there are lots of ways but all these proposals share this 18-year idea, which is interesting. As I said, I think it's constitutional. We need to have a national conversation about it. If it's not, I can't prove the negative. Someone's going to have to identify what in particular would be. But we think it's a better version of judicial independence. It'll reduce the stakes and because there's always going to be 1-2 years from now. They won't time their politically their exit strategies, et cetera, et cetera. So we think it's actually a superior model, and the Academy is trying to just jumpstart a national conversation about this.
Right. So Charles, is there anything you want to add on the constitutional question?
Well, I do think that our proposal is superior to the others suggested, because going back on the courts of appeal or any other regular federal court is a very responsible job, and it is very interesting. And you do not think of yourself as somehow being relegated to a dust heap or to a sinecure, as the White House proposal suggests.
Sheldon Whitehouse, not Biden White House. But here was the final thing. I knew that there was one other thing. If we only do it prospectively going forward, every single nominee knows that these are the conditions under which she or he is being confirmed and accepting the commission, and is in effect promising in advance to shift after 18 years. Stephen Breyer announces that he's going to retire upon the confirmation of a successor, Ketanji Brown Jackson. That actually took a few months. Senator O'Connor actually announced in advance, I will step down when a replacement is confirmed. Why can't you do that 18 years in advance rather than 6 months in advance? But you're agreeing to this from day one, and we're not pulling the rug out from anyone.
Let me just, we only have a few minutes. I'm thinking of the questions you want to ask, because we're going to have 10 or 15 minutes for questions. But I wanted to, there are two issues that we haven't addressed yet. And the first is how you would choose the Chief Justice. And the second is, well, what would happen if the Senate just refused to confirm? You know, every president gets 2 picks, basically. What if the Senate just refuses to confirm? How would this proposal address those issues?
So the Chief Justice, just to make the math work, the commission actually said there are a variety of possibilities. My own preferred mechanism, just because the math is so much easier, is just the chief is the most senior of the 9, and you're chief for a couple of years at the end, years 17 and 18, and you know actually 2 years before that you're vice chief, and you know that's going to happen, and so you just and everyone gets a turn, and that just keeps the math nice and easy. That's how many of the courts of appeals do it for their chief judge, their senior judge. That's how many apex courts around the world do it. Now, as to impasses, they can happen today as well. We think they're less likely because we've reduced the political temperature, because there's always going to be one 2 years later. But if someone rotates off early or dies early, the next president will just start with an extra one to fill. Look, impasses are going to impasses are leaving money on the table, because now the Senate's not getting someone that it might like, and the president's not getting someone. So they may have to come toward the middle. When the president faces an opposition Senate, he or she may need to actually move more toward the middle. But basically, I'm looking at my friend David McCullough here. Okay, it's extra innings, and you start with someone on second base. Okay, but the game is going to end at a certain point. You can actually the president who faces a Senate who dings the first name, and then dings the second name. You can actually move if you want the deal, and if you don't do it, then you as a president don't have as much of a legacy, and you as a current senator, because you might actually not get reelected, aren't going to play a role. They both have incentives to find a deal in the middle while they're, but if they don't, then there's going to be a seat for the next.
Consent. There's a limit to what you can do about it, right? I mean, you need to have the Senate.
But there are ways to change the Senate rules.
Like how?
Like how? So there's actually a bill in Congress right now introduced by Senator Merkley of Oregon that would effectively allow a committee of 30 senators to vote on a proposal that would bypass the committee process and move a SCOTUS nominee to the top of the Senate business. So it would basically be an amendment to the rule. Now, could 2 years later an amendment to the rule change? But the rules, you only need generally, I think, 51 senators for the rules, I'm pretty sure. We're good with 51? Okay. So it's a little bit, so you have 51 senators change the rule, and then 30 of those senators under this law would propose to move it to the top of the business of the Senate, so that would hurry things up. Look, there have been other proposals in certain bills. It's okay, you got to vote within a certain number of days. But I like the Academy proposal, and I'm kind of jealous I didn't think of it. Like, the president gets 2 justices on 2 appointments on January 20th. Let's just say January 21st, right? Not when there are vacancies, but over his 4 years, instead of waiting, the July of the first year and July of the third year, right off the bat you get 2 nominees, and then you've got, because generally when a president wins, they get a Senate with them, and they lose seats after the midterm, so that year 3 nominee is going to be hard to confirm, so you get 2 right off the bat, and then your second nominee of the 2 doesn't start serving until year 3. So they don't have a 20-year term, as it would if you were to do the math. They still have an 18-year term, but they don't start serving. So I think that's a really great addition that the Academy's report is doing by saying, look, while the president still has the momentum, early in the tenure, let's get those nominees out of the way. They're not going to start serving till later, but let's at least get them confirmed while you have a friendly Senate, or while you're more likely to have a friendly Senate.
Does anyone want to add anything on those two issues at all?
That we already have had some people confirmed but not commissioned, and if you can wait a few weeks after confirmation until you're commissioning, Gabe is saying you can wait 2 years between confirmation and commissioning.
And one more question. Oh, go.
Well, I
Kim.
was just going to say quickly, I have to, the one thing in the report that I quibble with a little bit is the selection of the Chief Justice. I understand that the Chief is not like the Speaker of the House. Maybe that's a bad example. There really are few. The Chief Justice is essentially, for the most part, has the same power as all the other justices. He's a first, or she is a first among equals. But there have been times throughout our history that having that position puts you in a place that even if on paper it is not your job, in principle and in theory, you are a leader and you have the ability to be a leader. I think of, for example, the Obamacare decision that that Chief Justice Roberts sort of quilted together almost. In a way that I don't think he could have done if he weren't chief. There are levers to that, and I think to sort of leave that job just to whoever's next is not necessarily the right thing. I also think, look, there is a sense when you win the presidency, to the victors go some spoils. I would be totally fine leaving that spoil to the president and letting the president continue to choose who the Chief Justice is. I think that would make good sense.
The thought was, in the spirit of evening everything out, every president gets 2, and it's not that Jimmy Carter gets 0 and Donald Trump gets 3. Every president gets 2 who will be for 14 years, in effect, an associate justice, just like everyone else.
But they would not get a chief.
Hold on. For the next 2 will be, in effect, the vice chief, knowing, actually this is how lots of committees work and all the rest, that they're going to be the next president, and then the final 2 years, that evens everything out. We always have a chief, and we know who it is. In those 2 years, that's your moment of leadership. You know in advance when it's going to happen. You can begin preparing for it, as opposed to actually right now, you're not even a justice. They bring you in as chief at the very beginning. You don't even know how the court works. You haven't worked with your colleagues. The courts of appeals and many state Supreme Courts and many apex courts around the world do it this way, and it's honestly worked pretty well.
I want to just point out also, this proposal is just about the Supreme Court. So I said to them when we were preparing, well, what about me? There are over 1,000 federal judges, trial court and appellate court. Why doesn't it expand to the federal judges as a whole for 18 years?
And if it turns out to be a good idea that people like, it probably will expand. Just like, for example, we have a 2-term tradition of the presidency. It was just an informal tradition, but it was followed most of the time, and eventually it became a constitutional amendment. So if this works well for the Supreme Court, you could imagine 10 years after that, it might be extended to other courts, possibly.
They'd never kick you off a court.
Oh, no. No, but we already have this senior status. I think that's the point. I mean, senior status.
And you already have the rotating chief idea,
right.
Which you're not appointed chief, on your first day. You become chief when you're the most senior.
So I think at this point, does anyone here have any follow-up? Because at this point, I was going to open it up to questions. I think. Are we there? Yes. We are there. So I think we're going to have mics. Don't be shy. I have a sense that this group will not be shy. So you're going to just.
Oh, wow.
You can pick if you like, but I can also.
All right, start over there, and we'll move across.
Thank you.
And
Hi,
there are
and thank
people
you.
behind me, so jump up if you.
Thank you all. I'm wondering why you are pitching the proposal as a term limit proposal. I'm not sure it is. You're saying that we still have the lifetime. You're really just shifting roles. So maybe you want to think about how you're communicating that to through the proposal. I'm also thinking you're not saying this is an expansion, but it will be an expansion for a period of time. To sell it to the public, I think that needs to be clarified, because there is going to be a lot of jockeying. One who's moving on. Are you shifting on, Thomas or Kagan or at what point does a president begin the two? There's going to be a lot of calculations, and so I think clarification around that expansion period. How many, do you anticipate will be on the court, at a period of time, for example?
Those are very helpful suggestions, and thank you. I do encourage everyone to read the report. We see this as just the beginning of a conversation that may take years, and by the time the end of that conversation, everyone will kind of look. I still haven't made my peace with the designated hitter rule. I admit, and I really don't like this starting with someone on second base and extra inning stuff. And I thought it was just going to be a provisional COVID thing. So we Americans know our baseball, but we don't know our constitutional law, and we need to. And this is just the first step in a national conversation, and the report, which I do hope you get a chance to read, actually worries a little bit about whether term limits really is the right label or not, because it's not quite right. And do we say, phased service, time rules? We welcome your suggestions about how best to even describe the thing for our fellow citizens.
So one of the suggestions you had in there were judges emeritus. So, there are other ways of talking about it. Charles, did you have anything you want to say, Charles? No. All right. Next.
Thank you. First, I want to commend the work of the commission and the work that you folks have done to explain it to us. It's long overdue. It seems to me to be a very good job. I've got about half a dozen questions, so I'll ask the most difficult one first, okay? And then if you run out of other questions, you can come back to me for the next most difficult one. So my question is, we think it's constitutional, but who's going to decide? Well, the Supreme Court is going to decide, right? Because this is surely going to, in the American litigious system, is going to get challenged all the way up to the Supreme Court, no matter what gets passed, and the Supreme Court will decide. Makes me nervous.
Yeah, I
How
think
do
if
you
we got
guys
to that,
feel about that?
I get that question a lot, and what I always say is, if we get to the point where a term limits bill passes both the House and the Senate and is signed by a president, I think it'll be so popular that the Supreme Court wouldn't dare touch it, number one. Number two, you have justices who support term limits. Justice Kagan has said that she supports term limits of 18 years. She said, that's 18 years, the going proposal. Oh, I'd be fine with it. Justice Breyer, when he was on the court, similarly said that. Chief Justice Roberts supported a 15-year term limit when he was in the Reagan administration. Justice Alito was asked about this during his confirmation hearing, and he said that he would either support life tenure or a very long term. Justice Kavanaugh helped write a speech that said we need to 180-day limit on Senate nominations to the Supreme Court so that we can't have the Merrick Garland problem. So he wrote that speech in 2002. So there are people on the court who have already thought about this, the current batch, and I think additionally, just thinking about the 9 that we currently have, and maybe we like them, maybe we don't, but it wouldn't apply to them. I mean, yes, we would be diluting their vote by 9 or 11%, but it would be applying to all the future justices, so they have the current 9 who would be deciding if the proposal is constitutional, have less skin in the game. So that also gives me hope that it would pass constitutional muster.
And it wouldn't be the first time the Supreme Court decided its own power. It did that in Marbury v. Madison, and the nation survived.
And the existing justices would be invited, of course. They might decline the invitation to testify if they felt so inclined. They are permitted under rules of judicial ethics to talk about judiciary-related issues. They might say, this could come before us, and so we don't want to opine. Note, though, that the new justices would be agreeing to this in the very confirmation process. In effect, they're buying into this by participating in a process in which the thought is, if confirmed, you're going to actually serve 18 years and then have a phase system. So they're buying into it from day one. If you had a time delay, which you could have, and phase it in, all the more everyone knows in advance what the rules are going to be going forward.
Did you want? Another question. Someone over there and then over there. We're supposed to be, I think we have about another 5 minutes. That's fine.
My question has to do with statute versus constitutional. Has there ever been a statute that passed that in any way impacted the structure, the composition, or, for lack of a better term, the behavior of the Supreme Court before?
Yes. The First Judiciary Act provided for 6 justices. In 1800, the Midnight Judges Act took it down to 5. The Jeffersonians came in and restored it to 6. Then it was 7. Then it was 8. Then it was 9. Then it was 10. Then it went back to 7. Then it went back to 9. I teach a course called Federal Jurisdiction. And this is what I taught this morning to the students. The Process Act of 1789 and then of 1790. The Federal Rules of Civil Procedure. The Federal Rules of Criminal Procedure. The Federal Rules of Evidence. There are ethics rules for the lower courts that are actually done by statute. There's an 1825 case written by John Marshall himself called Wayman versus Southard, saying, of course, Congress, under a thing called the Necessary and Proper Clause, Article 1, Section 8, Clause 18, but who's counting, actually explicitly gives Congress power over the other branches. From day one, you see, Congress decided how many justices there would be because the Constitution doesn't say. And to repeat, it's gone from 6 to 5 to 10 with everything in between. So the Congress over the years have added to the jurisdiction of the Supreme Court, and lower courts have taken away jurisdiction of the Supreme Court and the lower courts. So all of that's really old hat.
Charles?
I just wanted to add that Congress could, if it wanted to, reduce the jurisdiction of the Supreme Court to admiralty cases. It could do that. And on other times it has reduced it in various substantive ways. And that's clearly in the history, and that's clearly in the Constitution.
Let me connect to one other thing that Charles said, because he mentioned circuit rioting and saying that's not a disgraceful thing. It's not a sinecure, but it's also not a demotion. At the founding, justices basically served 10 or 11 months a year riding circuit. They spent 1 or 2 months at most sitting with each other in the national capital. And Congress had circuit riding, then it got rid of it, then it reinstated it, then it got rid of it. Okay, we're bringing it back in a certain way with senior status because we actually think it's not a bad thing for justices to understand at the end of their career, they're going to get out in the hinterlands, interact with local juries, with other judges, hear from citizens. That's a good thing. But all of that is very consistent with Congress over the years modifying the job description of judges and justices many, many times.
For example, Justice Souter, as you heard, sits with the First Circuit fairly frequently. So it's by no means unheard of.
For free. He gets paid either way. God bless him. He's just doing this because I mean that. I hold him in the highest regard. The Romans would really have respected a person of virtue and self-abnegation like David Souter, because it's never been for him about him. It's about public service, and God bless him.
I think he probably enjoys sitting circuit more than he enjoyed being on the High Court, honestly.
Was there somebody up there who had a question? Yes.
Hi, thank you. In the proposal, in a 4-year term, a president appoints 2 justices. What if they get reelected? They get 2 more?
Sure.
So then doesn't that, you're trying to make it equal for everybody, doesn't that make it more political and politicize things continually?
Well, if you've been elected twice, if you win the World Series twice, it's different than winning the World Series once. So every presidential term is entitled, in effect, to 2 seats. That's the thought. Now, it's not going to be perfect, because suppose someone dies or resigns early, then you're going to, inherit yet a third. But it seems, just very fair and even. The average tenure of the court until the modern era, amazingly enough, was about 15, 16, 17, 18 years. It's only been in the world of modern medicine where in the last 40 or 50 years, the average tenure has expanded pretty dramatically. So for most of American history, most presidents are putting people on the court who are serving, for most of American history, on average 18 years. And yes, if you're Franklin Roosevelt, you're going to get more because you're elected more. Although he got 0 in his first 4 years, as it turns out. But on average, people who have been reelected have had more opportunities than people who just got elected once.
And it's still less than a majority. And I think in the last 90 years, only once has a party that had a 2-term president then won the next election, and that was H.W. Bush. So there is going to be that flip over time. If you skipped the 5th and 7th year of a president, then I think that would end up averaging out to about 27 years. So to keep it at 18 years, it's not the best answer, but it's better than the other options. And because of the flipping of presidencies in terms of parties, it ends up, I think, being fair than the other options.
So I think we have time for one last question. Is there anyone who, way over here? Here we go.
And remember, on some of these details, this is just the beginning of a conversation, and we want you to read the report and make improvements if you've got them.
There are several countries where judges are trained, and a few of us have talked about that. If we moved in a direction of training judges as a separate track, would that affect this idea positively, negatively, or just a wash? Because training a judge is very different than taking defense or prosecutors and making them a judge.
So Charles talked about how one advantage of this system is you don't need to pick a 30-year-old to maximize your party's clout on the court because you're going to get 18 years. And so you might pick people who have a little bit more of a lawyerly and maybe even judicial track record for the Supreme Court. And he thought that's a great virtue, and that is one of the 18 advantages way back when I counted the thing. We are moving informally already toward a model of a separate judicial track. There are European countries, if you want to be a judge, you actually have separate courses in law school. You take a separate exam at graduation. You start out as a baby judge. You work your way administratively, bureaucratically up through the system based on seniority and your status, largely merit evaluations from other judges, and you move up more quickly or slowly depending on what other judges think of you. Informally, we're already in this world. I'm going to say something that you might not like, but here's how it works. If you want to be a judge, you go to one of 3 law schools, at a ridiculously young age, and then you do a clerkship.
Supreme Court.
Yes, if you want to be a Supreme Court justice. Oh my gosh. Okay, so we're already in this world where you go to certain law schools, get a certain training, start as a baby judge called a law clerk, and then you work your way up. So Justice Sotomayor was a lower court judge for 18 years, so was Stephen Breyer, so was Sam Alito. The most junior the justices on the court, here are some of them. Gorsuch did 3 clerkships, so did Kavanaugh. KBJ did a Supreme Court clerkship, and so did Steve Breyer, and so did Elena Kagan, and so did Chief Justice Roberts. The ones who didn't do Supreme Court clerkships often did lower court clerkships, like Sam Alito for Judge Garth. So we're already in a world, de facto today, where people are moving up within the judiciary more than being a former governor, Earl Warren, a former senator, Hugo Black, a former attorney general, Robert Jackson. There's a separation of career paths.
That's not necessarily a good thing.
That's what I was just going to
But
say.
that's increasingly what is already happening.
So I think that that is one thing that this proposal would allow, contrarily, is that it would take away some of that incentive. It would allow presidents the ability to think a little bit about who they're putting on, and it does not have to be the Yale or Harvard law graduate who is a former circuit court judge. That's 8 of 9 justices went to an Ivy law school. They all were former circuit court. That is terrible.
8 of 9, except for Kagan, was a sitting federal court of appeals judge at the time of appointment, and she was Solicitor General, as was Charles, which is often called the 10th justice, a very judicialized position.
Right. I would love a Supreme Court full of justices who understand the real impact of the rulings that they make. I don't want a Supreme Court justice that has never set foot in a trial court. I don't want a Supreme Court justice that has never been in a jail with a client. I don't want a Supreme Court justice or a court that has nobody on the court that has done that. I would love a Supreme Court full of educators, full of business people, maybe a scientist even. I would love people who understand what exactly it will mean when there is a nationwide injunction against the distribution of mifepristone and because a judge second-guessed the FDA. I would love a judge to understand what it means when people manipulate bankruptcy laws to try to insulate them from liability when they do something wrong and commit a mass tort. I would want a court full of people with a broad range of backgrounds, and I think this is one of the best arguments in favor of a proposal like this.
All right. So I think I just got the flag that our time is out. I want to thank everyone on the panel. I want to mostly thank as well the American Academy of Arts and Sciences for convening us and for coming up with really 2 important reports. I hope you go online and see the common purpose on this work, this paper that you've been talking about here on I think it's a good point on I'll call it the 18-year proposal. and David Oxtoby for spearheading it, and I just, everyone here for coming here. Some have flown distances to make it here today. So the Kennedy Institute, thank you, and I think we'll all say good night.
Thank you, Doug.